Thank you very much, Kathy, and of course it's a real privilege to be here on Wurundjeri land today to share with the findings of the PIPA report with you, which we launched formally last week after a very long journey, as these things often are. And I'm conscious that this is a particularly expert audience, and that a lot of you have been very familiar with the PIPA journey and have followed it right through. Many of you participated in it. I've also been sharing the findings with a whole range of colleagues and collaborators, including FSV, along the way. So I'm not about to tell you a whole lot of things that you already know. I'm also conscious that today is an amazing opportunity to bring together a focus for the whole day on this particular subject, and that there'll be, as Annette has identified, the sharing of a lot of really practice expertise, which is fantastic. So there are a lot of sort of themes in the PIPA report around that practice expertise and the kind of nuanced and additional and flexible intervention that Annette mentioned in relation to how we might like to build out services, as well as how we might like to develop workforce that are in the PIPA report, but I won't cover today because I think that's going to be very, very adequately covered throughout the day. As has been covered, the sort of what we know currently about adolescent violence, and of course there are many people in the room who have contributed to that knowledge and the data that we currently have. So what I'm going to do today is just take you through the findings from the PIPA project, which are possibly a bit different from some of the other work that's around, and that is the focus on the legal and service response. Now, of course, specifically the legal response. Now, we focused on the legal response because, as our name suggests, at the Centre for Innovative Justice, that's what we're about. We're about looking at whether the legal response or legal system in any context is functioning essentially as a positive intervention, or whether it's functioning as a negative intervention and either driving people into further harm or driving people away from help. And Annette mentioned, and has been mentioned, and as you all will know very well anyway, that adolescent family violence or adolescent violence in the home is a particularly underreported form of violence. So when we're thinking about, well, how is our system drawing people into support, what are we doing to understand the real prevalence, the real rate of a particular issue, we need to think about what our system response is doing to either prevent that from happening or keep it essentially underreported and unknown, and families living in isolation. So just to give you a sense of what we did in terms of the work of the PIPA project, it was a 2-year project of data gathering with an extra year of peer review process, etc. But over those 2 years, we spoke to over 150 practitioners across 3 different jurisdictions, and we reviewed 385 legal and court case files across those jurisdictions. It was a very detailed narrative review, so we weren't not very sort of numbers-based people at the CIJ. We're more about the narrative, we're more about the understanding what's sitting beneath the circumstances that bring people to the legal system, and then what that experience does to their further contact with the legal system or their future safety and support. So we were guided by a steering committee of pretty high-level stakeholders. The President of the Children's Court of Victoria was a fantastic support, and as chair of our steering committee, but also really as champion of the project, because she gets that there is a lot of work that needs to be done, particularly around the legal response, as does the Assistant Commissioner of Family Violence Command at VicPol. So when I now go into a description of the legal and response, which encompasses courts and police, I'm going to be pretty scathing, but in doing so, that is not to criticise any individual practitioners or any agency, the courts or police, because we're focusing on the settings that are there which allow or don't allow people to do their jobs and provide families with support and safety in the way that they might like. So just to give you a very quick, I won't go into the detail of the other jurisdictions, but just to give you a sense of why we looked across jurisdictions, we wanted to, it was precisely because we wanted to understand what the settings are and how those settings contribute to the kind of response that people receive. So as you will, obviously, as we're all aware, in Victoria, we have a very proactive family violence response. An expanded definition, we predominantly use civil protection orders as our first port of call before it falls into the criminal jurisdiction, unless, of course, there's behaviour identified as a criminal offence at first blush. But in the other jurisdictions we looked at were quite different. Western Australia had only just expanded their definition, but the mechanisms around the police response were a bit different. For example, whereas police in Victoria are told very firmly you must seek an intervention order if you feel that there is any risk at all, in Western Australia it tends not to work that way, in that the recommendation is still for the family member to seek an intervention order. So what that does to how adolescent family violence is appearing in the data and on the court files is quite significant, because we know that family members are particularly reluctant to seek intervention orders against their children. So whereas now the legislative definition might be the same, because those mechanisms are a bit different, we see that's contributing to the visibility of an issue in different ways in different jurisdictions. In Tasmania, the definition of family violence, they have a very proactive, fantastic family violence response, but it's limited to intimate partner violence perpetrated by those 16 and above. So officially on the legislative books, adolescent family violence doesn't exist. But what we found when we started digging was that there are a certain proportion of kids in out-of-home care excluded by virtue of just generic restraint orders, which was the result of the music violence in the home. And our data, our file review showed it was often very, very significant physical violence, which meant that the families really, really had waited, and they'd done absolutely everything else, but there were no services. And similarly, police had recommended that they seek the order. So while in Victoria, of 100 file sample from the Children's Court, only 2 of those applications were brought by affected family members, the rest by police, so a much higher rate than even in existing across intervention orders more broadly. It was basically the reverse in Tasmania in terms of how police levers are driving the visibility of the issue. So now looking at what we found just in the Victorian files, and this is something that goes to question, yes, we've got data, and yes, we sort of know that there's a consistent rate of intervention order matters or police call-outs relate to adolescents as respondents. But we have to, it's important always to unpack what sits behind that data, because what we found in the Victorian data and the case files really shocked us. Certainly we saw the kinds of patterns of behaviour that we would generally understand to involve adolescent family violence, but we also saw some cases that just simply didn't appear to meet the legislative definition of family violence at all, but police felt so compelled to bring an order that was brought to court, and an interim order at least was granted. Obviously, as we've heard, a lot of issues involve co-occurrence of a range of AOD, mental health, school disengagement is a huge one. But we also saw a proportion of matters that involved family violence perpetration in multiple directions. Intervention orders had historically been going this way and that across whole family structures, but for now the child was the target of the system intervention. And practitioners would say to us, well, you know, kids will say to me, well, I told the police that Dad did this, but they didn't believe me. Or the sense that kids are often voiceless and therefore kids become the target of the system's intervention. And I think it's useful to think about that in the context of children being identified as the silent or invisible victims of family violence by the Royal Commission. And obviously the mechanisms of our system discourage kids from being brought to court and being visible even in that context as protected persons for all sorts of good reasons, but they become very, very visible when suddenly they're identified as a perpetrator by the system, which is looking for a perpetrator and a victim survivor and can't quite deal with the fact that somebody might be both and very vulnerable at the age of 13, 14, 15. Was one of the most shocking, the final dot point, this is one of the things that really shocked us. And to highlight this is not to minimise the vast majority of experiences of victim survivors and families living with adolescent family violence, but we did see examples of files where the system essentially was being misused to continue perpetration of family violence against children. And it was only when a savvy lawyer kind of sussed something about their client who was there as a perpetrator and managed to get them to be referred into the Children's Court Clinic for detailed assessment that it became, that it emerged and disclosures emerged, because the child then felt safe to explain that they were experiencing significant family violence, and that perhaps what had happened is that they started to resist and act out. They get to a certain age and that's, well, we'll get an intervention order against you and that will control you. Now, so that was not, obviously that was a minority of files, but it's something that we heard from the practitioners across the study is something that they see and they're very conscious of. So again, it starts to problematise that idea of, well, we know that there is this certain number of children who are perpetrating family violence in the home and we must focus on that. So it's just a reminder to us that we need to constantly interrogate what sits behind the data at all times and what are the actual realities going on in families' lives. As Annette mentioned, PIPA's data showed that nearly 50% of children on the files had a psychosocial disability. So that includes mental health, but very significantly, nearly 25% of adolescents were living with autism spectrum disorder. And it was identified, it was diagnosed, it was on the file, and in many cases, many situations, that's not the case. Now, the reason that is significant, very, very significant, obviously it's significant for a whole range of reasons, but to lawyers, the reason why that is significant for one special reason is that the Family Violence Protection Act doesn't require currently any consideration of the capacity of the respondent to understand or comply with an order. Now, that contrasts with the personal safety intervention orders, the thing we might use in stalking situations, where that does require consideration of the capacity of the person to understand, and it contrasts with criminal law, a very, very important criminal law principle, which assumes that children 14 and under are not capable of understanding the nature of their behaviour unless it's sort of proved otherwise. So we have to sort of question both the fact that we are imposing intervention orders on children 14 and under, and we saw a significant number of, it wasn't just just a handful, we saw a significant number of files with orders imposed against 13-year-old kids, and 13-year-old kids who may not have the capacity to understand or comply with an intervention order anyway, given that intervention orders are so language-based and our legal system is so based on discursive devices and conversational approaches and sort of strange instructions framed in odd ways that most adults have trouble following. But if we're talking about kids with cognitive impairment who are not able to regulate their own behaviour, let alone understand that kind of instruction, then the findings in civil contexts are alarming and may be contributing to rates that we've found in other data that's emerged recently around high rates of kids breaching intervention orders or coming back into contact with police very soon after they've had contact as perpetrators of family violence. Across, this will come as no surprise to anybody in this room, across the research, trauma was a huge, huge theme. And it was really interesting that in the focus groups, it was so universal that it almost wasn't mentioned until the end, because it was just an afterthought. Well, of course, all our clients are living with significant trauma. Of course, all these kids have experienced previous violence. Now, there may be, obviously, that, we know that that's not necessarily always the case, but again, just zeroing in on the specific aspect of the legal system's intervention. Our legal system just doesn't deal with the question of pre-existing trauma very well at all. We sometimes will take people's experience into account into mitigation of sentence in a criminal matter, sometimes, and pre-existing trauma in kids is relevant and addressed in increasingly, though inconsistent ways, across some juvenile justice settings. But again, in the context of civil responses, we need to grapple with the increasing evidence that shows the impact of trauma on neurological development and the capacity of people to communicate, to understand or comply with expectations, as well as, of course, to trust and engage with adults as the system expects them to do when an order is imposed or a referral is made. You have had no reason to trust an adult your entire life, but off you go over there, see that person for 12 weeks, the same time each week, and just tell them everything about yourself and do what they say. So one of the other things that, of course, emerged was trauma in the lives of parents, and the impact of that on their own ability to grapple with, support their child, to respond to or the legal system's intervention, as well as, of course, creating additional barriers to effective responses, such as mothers being triggered by the behaviour of their child when they were seeing it replicated or replicating the behaviour that they'd experienced from their former partner. And across the research, we just heard time and time again, pretty much every focus group, if we're intervening in adolescent family violence, we're intervening 10 years too late, because we needed to get the support to the mums and the kids much, 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 much earlier. And one of the things that practitioners would say to us is that essentially child protection or authorities will get involved when it's got to crisis point. And then they start running the children around to lots of appointments and getting them to services and engaged. And the comment was, well, families will say, why didn't you just do that for us earlier? Why didn't you help us get our child the support and services that our child needed, that we needed, and then we could all still be together? Which goes to, and I think this goes to the specific question that came from the audience earlier, something that I'll cover the first point. Our research was geographically based because we were conscious that the response that people receive and families receive is still very postcode based. But it's not just about what services are available, it's about how they come together and whether they know about each other. And whether they have got their referral pathways working well, and whether in the context of the legal response, whether the local magistrate has any idea that they even exist or doesn't. So that's something that we have to be aware of. It's not just about getting the services there, it's about bringing us all together as a whole network, and I know there are people in the room who are working on that in different areas, that in Barwon, in Wyndham, and in Yarra and Drummond Street, and the network in Barwon, and a whole range of other areas that I don't want to name everybody in case I'm sure I'll miss one out. But that was one of the things that came out really, really strongly, that even if we fix the levers in the legal system, then we still won't solve or address the problem of adolescent family violence with just one kind of service intervention. It has to be a collaboration. And thus far, we've still all been moving forward a bit like this. And I know Annette referred to the orange door, and that's certainly starting to get there, but of course everybody is still a little bit overwhelmed as well and working out what all that means. So Orange Door needs to know and be confident about where things will go next, and that there's a safe network and collaboration of hands out there to catch the family. We heard that adolescent family violence was not widely recognised as a concept in many culturally and linguistically diverse communities, but we wanted to make sure that we didn't homogenise those communities, because when we're looking at legal files, it doesn't give you a lot of information about people's backgrounds. So I think what is more relevant is the issue of trauma, people's newly arrived and refugee experiences, their anxiety about statutory intervention and calling the police or having child protection involvement. So we wanted to be careful about sort of coming up with a finding on that one, but we certainly heard that from practitioners that mums from some particularly newly arrived communities would be more willing to report violence from their partner than from their child. But most of all, and this goes to that question earlier about adolescent family violence in Aboriginal communities, again, and it has responded to the fact that, yes, obviously service responses need to be community-led, but for us, the specific interest was about the fact that if our legal response and our statutory response is so punitive, so damaging, risks criminalisation, child protection involvement, so child removal, funnily enough, we heard from practitioners right across Victoria and right across the jurisdictions, we are not going to be talking to police about the use of family violence from our adolescents. We have a whole range of other issues to be dealing with, and we are not going to be bringing that into the fore. So I think it's something that that's one of our biggest priorities, is understanding what the legal system's intervention can have, the impact that it can have on recognition and or the support that people are able to receive. Okay. So I've just been given the wrap up from Kathy, and so what I just wanted to focus on was a little bit going to that idea of trust and engagement with kids. We found a lot of great examples of people doing fantastic work. Usually it was police or courts and lawyers using discretion and a bit of creativity to understand that the kid that they were dealing with that was in front of them was grappling with a whole range of issues, including pre-existing trauma, potentially intergenerational trauma, and they needed long-term engagement and support, not the hard intervention of the legal system. So the thing that tended to work was what somebody termed was old-fashioned youth work, going to where kids are, building trust, spending time, driving them to appointments, hanging out. So the people that were getting the disclosures were YSAS workers who were in the kids' lives because of AOD use, but then spending time in the car, they're all of a sudden, they would say, I'm a family violence worker. Actually, all I get is disclosures all day about the experience and their use of family violence. What am I supposed to do with that? And YSAS are doing a lot of work to skill up their workforce on that basis, because that's something that they're very aware of, and they're working with VicPol as well. And police similarly told us that they feel really stuck. Damned if they do and damned if they don't, because they want to be able, they understand that their discretion is needed, but the risk-averse nature of the current system is such that they feel compelled to follow these steps and then maybe in the background work out a better response for the family. Lawyers absolutely universally said, we cannot stand intervention orders. We will fight like hell. To do anything to avoid an intervention order imposed against our client. You may think it's better than a criminal response, but the shocking thing was that we heard was often the best thing that can happen for our client. If an intervention order is imposed, we just wait until they breach, and that's when they get the services. That's when they get diversion. That's when they get the therapeutic response. And that is an appalling state of affairs. That is an appalling indictment on our system. So, how can we make a difference? The good news is that we can, because we actually know what's not working about the settings. So the legislative settings are not working, but they can be. It doesn't mean throwing out the whole thing. It means putting more nuance into recognising the capacity of people to understand intervention orders. Thinking about the safety of where kids are placed if they're removed from home. And sometimes they have to be removed from home for respite, but currently we don't require any consideration for the court to think about the safety of that placement. That's just whether the person with whom they are placed has a criminal record. So our file showed us that kids are placed with grandma, placed with separated dad, or with girlfriends, so that just dispersing the risk. And as we've heard, the kinds of things that we've been talking about, and you will continue to talk about through the day, are also the things we can do in terms of workforce development and developing that way of working that responds to complexity and nuance rather than just a one-size-fits-all response. And now I will be quiet so that Kathy can tell me that I've finished and we can have questions.
Elena, thank you very much. So, such a good opening to our session, so just to hear all the data is so important. And I guess as a researcher, just the value of being able to get into case files, fantastic, and just a lesson to all those government departments out there that don't like doing that. There's a huge value in that space. So terrific. Yeah. I guess just one question from me before. It seems to me, is all legal intervention necessarily punitive? Because in fact, if you look at the Sabbats and the way they work with treatment orders, which are sort of in the Children's Act, that leverage seems to be important for some families and their young people with sexually harmful behaviours. Yeah. Just wondered if you want to make a quick comment like that and then we'd better move on.
I would, thank you, Kathy. And I'm almost imagining that I wrote that question myself. Yes, because as we've titled the report, Positive Interventions for Perpetrators of Adolescent Violence in the Home, it was kind of because there was a catchy acronym involved, but also because everything that we exist at the CIJ because we believe that the intervention of the law can and absolutely should be positive. And that's a really good example where in the context of treatment for sexual offending, it's an entirely therapeutic response. The challenge, though, is that the services have to be available and the resources for those services. So while the court, in those contexts, the court can make an order for the child and the whole family to engage with therapeutic services, and there's an onus on those services to report back to the court. So it's not just the onus on the kids and the families, which is hugely important. The services are accountable to the court. But if those services don't exist or there's not enough money and they can only take 6 people or whatever it is, then that's when that kind of thing breaks down. But yeah, absolutely. There can be, and there are often examples of amazingly creative and fantastic and positive intervention, but the current settings just don't support them in this context.
So thank you very much, and let's move on, but thank you so much. It's such a great report. I just really recommend it for everybody to have a read. It's publicly available.
Yes, thank God.
And so, that's a wonderful thing. So thank you.